A very common situation in criminal law is where the police charge multiple co-accused with the same crime. For example, a drug case where they find multiple people in the same car, they don't know who had possession of the drug, multiple people in the same house during a search warrant. A client comes to me and they say, Mike, my wife and I were found in this car together. Can you represent both of us? Well, it really depends. Let's say there's four people in the car. Both the husband and wife are saying the drug wasn't ours, but it was the driver's, and they're both saying that. Well, that technically would not be a conflict of interest, and a lawyer technically could represent both the husband and wife, as long as that story doesn't change. Sometimes a conflict of interest could occur at a point later. For example, the wife says, no, the drug was my husband. So it's always a bit touchy situation to take on co-accused. That would be one where you could. Our firm, I'm not saying we never take on a co-accused, but we're very careful about it. We have to assess each individual situation. We have to make sure there's no conflict first. The way we do that is we only represent one initially, get the disclosure, review it carefully with them, and make sure there's no conflict, and then perhaps we might be able to represent the husband in that situation. Now, there's other touchier situations where there is no conflict. Yeah, you could represent two, but it may not be in the best interest because it's a very complicated factual situation, like a very complicated factual situation, say a fight on a golf course involving multiple parties. So now you're cross-examining at trial for two people. It becomes messy in your mind to sort things out. Who are you helping at any one given time, even though both your clients saying the other four golfers were the aggressors? So you have to be careful. I wouldn't recommend a criminal lawyer take on many co-accused cases. Maybe there are cases that are okay to do it, many not. But I can tell you this, there's so many examples of conflicts of interest where you can't. And again, that would be an example of the car where, say there's four co-accused, a man in the car says the driver it was the one possession of the drug. So the man wants to retain me. Well, I can't represent the driver because we want to point the fingers at the driver. So conflicts of interest occur at the outset in criminal law. They can also develop during the course of a trial. So that becomes a messy situation too. So two people have paid a lawyer all this money and a conflict occurs in the middle of the trial. The trial gets mistried and put over, and where do you go from there? So you have to be very careful as a criminal lawyer, and you have to understand the law of conflicts very carefully. So that's the short answer of when and when not you can develop a conflict, and whether a lawyer should actually consider taking two co-accused on. The bottom line is the lawyer has to be very careful and do the right thing. It sometimes doesn't pay to take two co-accused on, even though there's no conflict.